Good afternoon, morning, evening, whenever it is, not legal advice. Please like, please subscribe, please share, please comment. I do look at everybody's comments. I do respond if I can answer cogently, which is not often. It's just opinion, as stated by the name of the title of the whatever this is. What do you call? What do wind turbines think of renewable energy? They are fans, of course. What do you call it when an electron cheats? A current affair. And I always take life with a grain of salt, a slice of lime, and a shot of tequila. You know what I'm saying? Anyway, I wanted to talk today a little bit about the ongoing proceedings in Delaware involving Tesla and the status of that. So yesterday was the hearing on the. So what's going on is the trial happened, a result was issued. The only issue that remains now is attorney's fees. Until the attorney's fees is decided, it's not a final judgment. Obviously, there's an issue of ratification that also is present. That is not yet set for a hearing, but will be. So yesterday was the hearing regarding attorney's fees that happened in Delaware. It lasted several hours. Both sides presented evidence. Both sides put on their experts. Now, their experts, that they had already submitted expert declarations, so it either supplemented that or was for purposes of cross-examination, or the judges had questions, but it didn't change the basic positions of the parties. There was a lot of discussion about how to calculate what is the most appropriate. Again, what makes this particular matter odd and more difficult is there's no pot of money. It's more of called like a therapeutic remedy, not a pot of money that was obtained. What also I found was interesting is either during this proceeding or just before, the plaintiff's counsel, so plaintiff is the one who's bringing the claim, their attorneys, in this case, all is about plaintiff's attorney, threw out the figure of 1.44 billion in attorney's fees. That's substantial if you kind of figure out relative to what they were asking for before. Even though it is obviously exorbitant, it also reflects a substantial drop. I don't know if they were just testing the waters, but they threw it out there. And again, 1.44 billion. Now, I think they should receive zero, but moving down is good. So that's what happened. So there was a big discussion during the proceedings about how to calculate, what's the best calculation. And at the end of the proceedings, they finished, apparently, at the end of the day, and the judge took it under submission, which means that the matter is now set for decision and that no further evidence can be offered. Now, if something new happens, of course, that could be offered, just like in Tesla's position, the ratification was something new, and that's why it was raised after the fact. Now, in terms of timing, about when a decision will be reached, and there was some discussion about this before, is if there is going to be hearings on the ratification, I'd be very surprised if the court, Judge McCormick, issued a ruling on the attorney's fees prior to the time of the ratification. If she issued a ruling that favored the ratification, then the attorney's fee motion as presently structured would be moot because they wouldn't be entitled to attorney's fees. But we haven't even had hearings, or I don't think all the briefs are complete as to ratification, so we don't know where that's going to go. But as to the attorney's fee side, so they argued it, they had presented a bunch of briefs, and now the court, Judge McCormick, has to decide. But is she going to decide right away? I don't think so, because there's a case that's pending before the Delaware Supreme Court involving Dell Technologies, and it's basically the court is trying to figure out what the appropriate measure is for attorney's fees. And I think one of the problems that the law in Delaware has in the calculation of attorney's fees and class actions is it's not really well enough defined in terms of how you should calculate it under specific circumstances. So the Dell case, for example, which is the case on appeal up at the Delaware Supreme Court, involved a situation where the award, I think it was an agreed upon award, and I don't think there was any dissent from defendant in the attorney fee award either. But they obtained a $1 billion. That was the agreed upon settlement. So $1 billion was actually obtained. And you've heard the term benefit, common fund. Here is an actual benefit of $1 billion. And they agreed, both sides, that I think it was 28.5%. So I think it was 285 million that was appropriate. It got reduced to 267 through some hodgepodge, but that is now up on appeal in the Delaware Supreme Court, based and in large part on the attorney's fee award and how to calculate it and what's the most appropriate way of doing it. So the Supreme Court rules, if the case is still pending involving Elon, that would control how Judge McCormick would make her calculations in attorney's fees. So if there's any issues that are involved in the Dell case involving attorney's fees, those could apply to the Tornetta case. And I think the court's going to wait probably till Dell case decided. The Dell case oral argument, so just like in other proceedings, they file a bunch of briefs and they have oral argument before the Delaware Supreme Court. That happened in May. And generally, they're supposed to dispose of cases within 90 days after the submission of the case. That would bring us to June, July, August, something like that. Now, of course, it could go longer, but at some point in time, they'll issue a ruling. And again, that might be applicable or not to the ratification, pre-ratification, we don't know. But it may decide how to calculate attorney's fees. So the Judge McCormick, if she's inclined to grant attorney's fees, I think she will wait to see what her higher court terms gives her in guidance. The other thing was I looked at a bunch of cases and some research that had come out before, and they're talking about how and on what basis they give attorney's fees. Why should they? And part of it is based upon public policy. There's certain things they want to encourage lawyers to do, and if there's certain conduct that needs to be addressed by allowing recovery of attorney's fees in some fashion in class actions, that's why it's encouraged. But they do treat when a benefit is actually conferred versus kind of the therapeutic benefit when there's some mispractice and you're correcting the practice, not where you're bringing in a bunch of money. And in this particular case, plaintiff's counsel, the ones who this case is all about, they are talking about the benefit conferred. So what is that benefit? I really don't know, because it's a Pyrrhic benefit. It's not a real benefit because the only benefit they got was for one day after the judgment, and it's not final yet, so nothing has happened. So as of right now, they've got nothing. But let's say there was for a day, they were able to get the plan actually voided, because it hasn't been voided technically yet, because the judgment is not final. It can be undone the next day. So what is the real benefit? There is no real benefit. On top of that, even if the pay package was deemed void, Elon could, and I'm not suggesting this to anybody, not encouraging anybody to do this, but theoretically, what would happen if Elon didn't get paid? So then he went to Tesla and said, yeah, I need to get paid for that time. I'm entitled to the reasonable value of my services. So if you don't agree to give me the money, I'm going to sue you. And without a lawsuit, there's an agreement whereby Elon is paid the reasonable value of his services. And what happens if the reasonable value of his services is what he was going to get paid in the pay plan or greater? And at that point in time, that would happen in Texas. It wouldn't be that pay plan. And there may be other issues with taxes. There may be negative effects beyond that, but there may be a way of adjusting it through quantum merit, which gets to the point is, what's the benefit that's been conferred by plaintiff's counsel? I really think it's minimal at most. It's a therapeutic benefit. So, if they were correct, then there should have been more disclosures. Okay, that's been taken care of. So the law in Delaware is, If it's a therapeutic benefit, then it only should be a modest award of attorney's fees, not the gargantuan award that they're seeking, even if that gargantuan award is now 1.44 billion. So how do you calculate it? And in the discussion prior, they were trying to figure out what's an appropriate way of calculating a modest fee. I think you have to tie it to hours. The lodestar method, which again, lodestar is hours. This is really exciting stuff. Hours times the rate. So, 1 hour times $1,000 an hour gives you the $1,000 times some premium to encourage counsel to go after these type of cases. So would that premium be, 1.5? Could it be 4, 5? It's possible, but I don't think it would be much beyond that. And I'm speculating at that. So if the court wanted to award attorney's fees and wanted to get upheld and found that they were only entitled to modest fees because there was no real benefit conferred and it was only a therapeutic benefit, and they took the value of the hours billed by plaintiff's counsel, which is something like $13 million, times some premium of 1.5 to, let's say, 4, I would say that would be the range of attorney's fees. I would think more between, let's say, 2.5 to 4, somewhere in there. That range probably would withstand appeal, and the judge might like to fit something in there. Now, depending on how this outcome goes, the attorney's fees, one side or the other is going to appeal anyway, because plaintiff's counsel, this is their big payday in the sky. They're just not going to let it go. And obviously, if some exorbitant award, and a lot of us believe any award would be exorbitant, but if some exorbitant award is issued, then Tesla would appeal, of course. So I think I addressed the issues. They had the hearing. The case is under submission. The judge will rule at some point in time. I think she's waiting for the Delaware Supreme Court to rule in the Dell Technologies case, where they're deciding how to handle the calculation of attorney's fees. And by the way, I should have mentioned this. One of the theories they look at was whether there should be a declining percentage as the money goes up. So, for example, if you recover $100 million, the first million should get you the biggest fee, and then at 10 million, you get a smaller fee, because you're putting all the energy towards getting that first one. So as you go down, it's really some ways a windfall as you go higher in number. So some of the experts have suggested the bigger the fee, and as you go, the smaller the percentage. And there's other theories. But anyway, so that case is on a appeal before the Delaware Supreme Court. Judge McCormick is probably waiting for that ruling before she will decide attorney's fees, if she decides attorney's fees. The ratification proceeding will be going forward probably sometime in late July or early August. That's what she indicated before. Depending on how the ratification goes, we will either get a ruling on attorney's fees or not. If the ratification is granted, then obviously there will be no need for that attorney's fee motion. And the thing that I'm waiting to see is how she interprets her May 28th letter, because I think that will be decisive in terms of her ruling on the ratification. And we'll talk more in detail about that when we get closer to the hearing, when we hear it. And I think there's additional briefs that will be filed, and we'll keep updated. I will certainly keep you updated as to that when the time comes. I think that covers it for today. If you have questions, comments, whatever, feel free to put them, let me know. Take care. Have a great day. Be well.